4. Documentation and Evidence. Part 1. يا أيها الذين آمنوا إذا تداينتم بدين إلى أجل مسمى فاكتبوه وليكتب بينكم كاتب بالعدل ولا يأب كاتب أن يكتب كما علمه الله فليكتب وليملل الذي عليه الحق وليتق الله ربه ولا يبخس منه شيئا فإن كان الذي عليه الحق سفيها أو ضعيفا أو لا يستطيع أن يمل هو فليملل وليه بالعدل واستشهدوا شهيدين من رجالكم فإن لم يكونا رجلين فرجل وامرأتان ممن ترضون من الشهداء أن تضل إحداهما فتذكر إحداهما الأخرى ولا يأبى الشهداء إذا ما دعوا ولا تسأموا أن تكتبوه صغيرا أو كبيرا إلى أجله ذلكم أقسط عند الله وأقوم للشهادة وأدنى ألا ترتابوا إلا أن تكون تجارة حاضرة تديرونها بينكم فليس عليكم جناح ألا تكتبوها وأشهدوا إذا تبايعتم ولا يضار كاتب ولا شهيد وإن تفعلوا فإنه فسوق بكم واتقوا الله ويعلمكم الله والله بكل شيء عليم وإن كنتم على سفر ولم تجدوا كاتبا فرهان مقبوضة فإن أمن بعضكم بعضا فليؤد الذي اؤتمن أمانته وليتق الله ربه ولا تكتموا الشهادة ومن يكتمها فإنه عاصم قلبه والله بما تعملون عليم. Believers, when you acquire a loan for a fixed period, record it in writing, and let a scribe write it down between you with fairness. And he who can write should not refuse to write. And just as Allah has taught him to write, he also should write for others. And the one who has acquired the loan should have the document written down, and fearing God his Lord, he should not make any reduction in it. If he on whom rests the responsibility of writing is indiscreet or feeble or unable to have it written, then let his guardian do so with justice. And call in 2 male witnesses from among your men. But if 2 men cannot be found, then 1 man and 2 women from among your likable people, so that if one of them gets confused, the other reminds her. And witnesses must not refuse when they are summoned. And whether the loan is big or small, be not negligent in documenting the deal up to its period. This is more just in the sight of God. It ensures accuracy in testifying and is the most appropriate way for you to safeguard against doubts. But if it be an everyday transaction, it does not matter if you do not write it down. And call in witnesses also if you sell or purchase anything. And let no harm be done to the scribe or the witness. And if you do so, then this will be a transgression which will cling to you. And fear God and understand that God is teaching you. And He has knowledge of all things. And if you are on a journey and a scribe is not available, a loan can be taken by placing something in possession of the lender against the loan. Then when circumstances are such that people can trust one another, the lender should return the thing entrusted to him, and he should keep fearing God his Lord, and should call in people to bear evidence on this matter. And do not conceal evidence in whatever form it is, and remember that whoever conceals it, his heart will become sinful. And remember that God knows whatever you do. Surah number 2, verses 282 and 283. This verse directs Muslims to document monetary transactions, whether in cash or in credit, to safeguard against any dispute that may arise. Imam Amin Ahsan Islahi has summarized the directives mentioned in this verse in his Tadabbur-e-Quran in the following words. 1. Whenever a loan is acquired for a certain period, the transaction should be written down in the form of a document. 2. This document should be written down in a just manner by some scribe in the presence of both the parties. He should not be fraudulent in writing this down. A person who knows how to write should not refuse if he is called upon to do so. The skill of writing is a blessing of God, and in gratitude to this, a person should help others whenever the need arises. The need for this piece of advice arose because in those times very few people knew how to write. Formal and legal documentation and registration had not begun, and neither was its inception an easy affair. 3. The responsibility of writing down the document rests on the borrower. The document should state the name of the person from whom he has borrowed, and like the person who has been entrusted with the responsibility of writing down, he should uphold the virtue of piety in this affair and in no way try to damage the parties involved. 4. If the borrower is naive, feeble, or is not in a position to write down the document, then his guardian or attorney should have it written down on his behalf with justice and fairness. 5. 2 male witnesses should testify over this document. The words used are min rijalikum, or from among your men, which imply 2 things simultaneously. Firstly, the witnesses should be Muslims and known to the parties involved. The second thing which is specified in this regard is that the witnesses should be honest and trustworthy and of sound character. 6. If 2 male Muslims having the said abilities are not available, then 1 man and 2 women can be selected to fulfill this responsibility. The requirement for 2 women is because if one of them commits an error, the other may correct her. This is not because women are inferior, but because this responsibility is not very suited to their temperament and general affair of interests and the environment that they are used to. Consequently, the Shari'ah has given them some relief and assistance in it. 7. People who have borne witness to a document should not desist from giving their testimony when they are called upon to do so, because bearing witness to a truth is a great social service also, and as witnesses to the truth, it is a responsibility of the Ummah imposed on it by the Quran. 8. If the loan, whether it be small in amount or large, is acquired for a period and is not an everyday loan, one must not show aversion to writing it down. People who ignore this by considering it a burden sometimes get involved in severe disputes which produce far-reaching results merely because of this negligence. 9. All these directives are in accordance with justice, and they safeguard testimonies and protect people from doubts and disputes. So, it is necessary to follow them for the general well-being of the society. 10. Everyday loans and transactions are not required to be written down. 11. Witnesses, however, should be called upon important deals and transactions to resolve any disputes that may arise. 12. It is not proper for a party to harm the scribe or witness if a dispute arises. Scribes and witnesses do a great social service, and if they are harmed, honest and cautious people will start avoiding these responsibilities, and except for professional witnesses, people will have difficulty in finding witnesses who are reliable. In present times, the reason honest and serious-minded people avoid these responsibilities is that whenever some dispute arises in such an affair, the witnesses have to face a lot of trouble and discomfort. They become the targets of defamation, suffer monetary losses, and even get killed. The Quran has stopped people from such excesses and warned that this is not a small offense that may be forgiven. It is a transgression which will cling on to them, and they will not be able to save themselves from its evil consequences. Amin Yasir Islahi, Tadabbur-e-Quran, Volume 1, pages 640 to 642. At the end of the verse, the Almighty has given His guidance on the issue of pledging something to acquire a loan. As per this guidance, if a person is on a journey and no scribe is available to document the transaction of loan, then the borrower can place something in possession of the lender as a security. However, this permission to the lender to accept such pledges is strictly dependent on the fact that the lender does not find himself in a trustworthy situation. As soon as such a situation arises, the Almighty has directed the lender to return the pledged item and call in witnesses over the transaction of loan. Imam Amin Yasir Islahi writes, When circumstances arise that people can start trusting one another and the lender does not have a valid reason to distrust the borrower, he should return the pledged item, and if he wants for his own satisfaction, he can adopt the method on which he has been guided earlier in the verse. Examples of these circumstances are that his journey ends, scribes become available to document the transaction, and in the presence of people known to him, the loan becomes a verifiable transaction. Here, the pledged items are called a trust by the Quran, from which it is evident that these items lie with the lender as a trust, which must be safeguarded, and it is prohibited to gain any benefit from them. Amin Hasan Islahi, Tadabbur Quran, Volume 1, page 643. The nature of calling in 2 male witnesses and in their absence 1 male and 2 female witnesses, though, is absolutely specific. However, the way our jurists have interpreted it requires that the following 2 aspects be kept in consideration. Firstly, the verse has nothing to do with the bearing of witness over an incident. It explicitly relates to testifying over a document. It is very evident that in the second case, witnesses are selected by an external agency, while in the first case, the presence of a witness at the site of an incident is an accidental affair. If we have written a document or signed an agreement, then the selection of witnesses rests upon our discretion, while in the case of adultery, theft, robbery, and other similar crimes, whoever is present at the site must be regarded as a witness. The difference between the 2 cases is so pronounced that no law about one can be deduced on the basis of the other. Secondly, the context and style of the verse is such that it cannot relate to law or the judicial forums of a state. It is not that after addressing a court of law that it has been said that if such a lawsuit is presented before them by a claimant, then they should call in witnesses in this prescribed manner. On the contrary, this verse directly addresses people who borrow and lend money over a fixed period. It urges them that if they are involved in such dealings, then an agreement between the 2 parties must be written down, and to avoid disputes and financial losses, only witnesses who are honest, reliable, and morally sound should be appointed. At the same time, their personal involvement and occupations should be suited to fulfill this responsibility in a befitting manner. Precisely for this reason, Muslims are directed to primarily appoint 2 male witnesses and, in their absence, 1 male and 2 female witnesses, so that if a lady, used to the serene surroundings of her house, finds herself overwhelmed in the hostile atmosphere of a courtroom, another lady is present alongside her to protect the evidence from doubt and ambiguity. The verse does not mean and should not be taken to mean that a lawsuit will only stand proven in a court if at least 2 men or 1 man and 2 women bear witness to it. It is merely a guidance for the general masses in their social affairs and counsels them to abide by it so that any dispute can be avoided. It is for their own benefit and welfare that this procedure should be undertaken. In no way should this bearing of witness be taken to mean that it is a statutory count for a testimony which a court must follow. Consequently, about all similar directives, the Almighty says that this procedure is nearer to justice, protects the testimony, and safeguards people from doubts.